The Fifth Circuit recently ruled that suppressors are not arms and therefore do not trigger 2A protections. However, in this case, we just got a very important notification from the DOJ and the AG's office, which essentially signals that there is going to be a radical shift in how the federal government is going to treat suppressors. Now, really quick before we jump into this video, I just want to mention that looking at some analytics, about 58 to 60% of all viewers are actually not subscribed to the channel. So if you want to support the channel for free, please consider subscribing. That does help the channel to grow and reach more people. And then also just drop a positive comment down below, because that lets the algorithm know that you appreciate this type of 2A content, and it should share my video and other people's video to more people to spread 2A news. As I mentioned in the intro, in this video, we're going to be discussing a suppressor challenge case that was recently ruled on by the Fifth Circuit Court of Appeals, and that was ruled on by a 3-judge panel at the beginning of this month. Now, right now in this case, the Fifth Circuit is being asked to review that decision en banc because the Fifth Circuit 3-judge panel ruled that suppressors are not arms and therefore not protected by the Second Amendment. This case is U.S. versus Peterson, and it deals with the constitutionality of the NFA as it applies to suppressors. This case involves an individual who had a gun store that was raided by the ATF. And during that raid, the ATF found a single solvent trap that was not registered, it was not serialized, and because of that one item, Mr. Peterson was charged with violating the NFA, and he was charged criminally. Mr. Peterson challenged that conviction based on the theory that the NFA and its suppressor restrictions do in fact violate the Second Amendment. And on review, the Fifth Circuit 3-judge panel found that suppressors are not arms, and because of that, they do not trigger 2A protections. However, now this case has been filed for Fifth Circuit en banc panel review, and the DOJ, through the Attorney General's office in Pambondi, they signaled a major federal shift on how suppressors are going to be treated. Last we talked about this case just a couple days ago, we found out that some of those Biden administration holdovers within the DOJ had filed a brief in this case. They argued that the Fifth Circuit should uphold the lower court's decision that suppressors are not arms and therefore not protected by the Second Amendment. But now, just a couple days later, the new Attorney General's office and the new attorneys in the new DOJ have notified the court that they want to hold this case for 30 days so that they can reconsider and reevaluate and potentially change what their position on suppressors actually is. This could also signal a major shift in suppressor restrictions nationwide based on what position the DOJ and the ATF take on these items, and also what position they take in this lawsuit. Now, in this case, back in 2022, both federal and state law enforcement officers executed warrants against Mr. Peterson in Louisiana. A federal task force included ATF agents and then 50 other law enforcement officers, and they raided his home. The search warrant was based on some issues where Mr. Peterson had operated a gun store out of his home, and there was issues about some of the purchases. There was claims about potential straw purchases, improper record keeping of 4473 forms, and I think the big one that really, triggered the ATF and the federal government to get involved were some of those purchases, some of those items were later found at crime scenes. During this raid, federal agents seized his entire inventory, which totaled about 300 firearms, and they also, gathered all of his personal firearms. Now, the one thing that they found, and the really one thing that got him in trouble and led to this lawsuit, was a single solvent trap that was in his home safe, and it was locked away in his bedroom. And because of that single item that was not registered and it was not serialized, he was charged criminally with violating the NFA. Now, in response to that charge, Mr. Peterson filed a motion to dismiss the charge based on the Second Amendment. But on review, the court denied his motion to dismiss, and then that led this case to make its way to the Fifth Circuit. And what Mr. Peterson was asking for was the Fifth Circuit to reverse that decision. But on review, the Fifth Circuit sided with the ATF and the DOJ, finding that Mr. Peterson's motion was properly dismissed and rejected, and that he did not make a valid Second Amendment claim. In that ruling of the Fifth Circuit, they stated that whether suppressors constitute arms is an issue of first impression in our circuit. And so far as we can tell, every court to have addressed it has decided the question in the negative. Here, the Fifth Circuit looked at whether suppressors are weapons of offense or armors of defense, or if they're used to cast at or strike another, because that is one of the main definitions of what an arm is. The Fifth Circuit incorrectly found that suppressors are not arms. They stated that Peterson posits that suppressors are an integral part of a firearm and therefore warrant Second Amendment protections. But that is wrong, they stated. A suppressor by itself is not a weapon. Without being attached to a firearm, it would not be of much use for self-defense. And unless a suppressor itself is thrown, it cannot do any casting or striking. So the Fifth Circuit went on to find that suppressors are not necessary accoutrements of a firearm, that they're not required to actually make a firearm function. They're not, 100% useful, and they are not needed to make a firearm actually shoot a projectile. And based on that, they upheld what the district court said. Now, that inherently was a very concerning decision, and that's what then led for Mr. Peterson and his counsel to seek a rehearing en banc in the Fifth Circuit. Now, like I mentioned just a couple days ago, we found out that the DOJ responded to that petition for a rehearing en banc, and they argued against the rehearing. They wanted the Fifth Circuit to not rehear this case, to essentially uphold what the three-judge panel said and what the lower court said, and they made arguments essentially still arguing that suppressors are not arms and that they're not protected by the Second Amendment. In the last video, I told you all that this was likely done by some Biden administration holdovers, and that this case was likely one of those cases that's just simply slipped through the cracks, that the new AG's office and the new Trump administration hadn't fully gotten control of all the cases, of all the areas and all the jurisdictions, and that we were probably going to see some changes in this case and other cases going forward. Well, it appears that I was right, because the AG's office, Pam Bondi, and then also the DOJ just notified the Fifth Circuit that they want to hold this case for 30 days so that they can reconsider their position on suppressors and potentially issue a new brief in this case, changing their arguments on what they believe suppressors are and whether or not they are protected by the Second Amendment. In the notice to the Fifth Circuit, the federal government states that the United States of America moves this court to delay its ruling on defendant George Peterson's petition for rehearing en banc for 30 days to allow the government an opportunity to further consider its position. On February 6, 2025, this court affirmed Peterson's conviction for possessing an unregistered silencer, holding that silencers are not arms protected by the Second Amendment. After affirmance, Peterson filed a petition for rehearing en banc, which was supported by amici curiae in their briefing. On March 18, 2025, the government filed an opposition to Peterson's petition for rehearing en banc, arguing that the panel's holding was correct. The government now requests this court delay its ruling on Peterson's petition for 30 days to allow it an opportunity to further consider its position. On February 7, 2025, the president issued executive order protecting Second Amendment rights, directing that the Attorney General examine all executive actions to present a proposed plan to protect the Second Amendment rights of all Americans. In implementing that order, the DOJ is reevaluating its litigation positions regarding silencers. Accordingly, the government respectfully requests that the court delay ruling on Peterson's motion for rehearing en banc for 30 days. At that time, the government will inform the court of the status of its review and, if warranted, move to leave to file an amended response in this case. So why is that such an important update? Well, in the last video, I told you all that the DOJ was still pushing forward in this case, asking for the Fifth Circuit to uphold the finding that suppressors are not protected arms, and that essentially the lower court got this case right. Those arguments by the DOJ were very interesting, especially since the AG had already been directed by Trump through the executive order to shift all the administration policies, including all litigation, towards mainly protecting Second Amendment rights. But it appears that this one case kind of slipped through the cracks, and some of the rogue leftover Biden administration holdovers and attorneys were trying to move this case forward in a more anti-gun posture. But that was just completely stopped. The Attorney General and her office and the DOJ are putting a hold to this case. They're asking for a 30-day hold, and they're going to reevaluate the potential entire position in this case. And if they shift towards actually saying that, yes, suppressors are arms protected by the Second Amendment, they're saying and signaling to the court that they will issue a new brief and essentially argue that, yes, suppressors are protected. So now this case will be on hold likely for 30 days, and then we will see an update from the AG's office about how they want to proceed forward in this case. The AG's office will now reevaluate the position on suppressors, which I suspect will be drastically different from what we just saw the Biden administration holdover attorneys argue in this case. It's going to be likely night and day about what position they take. This also likely signals a radical shift in how the federal government will treat suppressors nationwide. So again, very important case. Unfortunate decision by the lower court, but now we're finally seeing the Trump executive order taking effect, and we're now seeing this trickle into some of these critical cases. So as we get more information, as things change, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.